Next case in the cause list is of NA Trading Company versus Commissioner State. The matter will be argued by the group's convener, Advocate Narender Ahuja ji, and the Commissioner has withheld the refund under Section 5411. The appellate has chosen to file an appeal directly before the Appellate Tribunal.
Mr. Counsel, my first question is why you have come to this tribunal directly without going to the first appellate tribunal?
Yes, I am coming on that point. May I proceed?
Yes.
Your Honor, this appeal is filed against the infant order of withholding the refund of rupees 17,85,000. This is a simple appeal placed before the Honorable Tribunal. Although the order was signed by the proper officer, but it was passed by the Commissioner and on the direction of the Commissioner. That's why I came here.
It was on the direction or passed by the Commissioner.
You see the order. See the order.
There may be two things.
The order.
One, Commissioner has some information and he passes on that information to the concerned officer. Another is that he gives a direction.
He has given the direction to the proper
shows
officer.
where that direction is there.
See page number 16 and 17 of the order.
Page number 69.
Yes, 16. 16.
Oh, that's a 16. Yes.
On page number 17, paragraph number 1, 2, 3, 4. In the meantime, Commissioner, after having got the report from the DGGI dated 27/11/2025, called for the records from the ward and directed to initiate proceedings against the taxpayer. And in terms of section 54 subsection 11, and section 54 subsection 11 only empowers the Commissioner to withhold the refund. That's why I came here. Now may I proceed further?
Yes. What was the reason why your refund was withheld?
There were some investigations among some bogus traders, and it was alleged that 16 out of the 20 suppliers from whom my client was purchasing raw material were among those bogus traders. So it was alleged that. That's why the Commissioner has directed the proper officer to withhold the refund.
Come again to page 17.
Yes.
Where you say, the meanwhile, Commissioner, after having got the report from the DGI dated 27/11/25, called for the records from this ward and directed. Is there any document to show that there was a direction issued by the Commissioner?
No, it was only mentioned in the order.
It has been mentioned in the order?
Yes, it was mentioned in the order.
Where has it been mentioned in the order or the show cause notice? Please show us the page.
17, page number 17 of the order. Page number 17, order. In the meantime, Commissioner.
It is the order of the Commissioner. Oh,
yes.
Order of the proper
officer. Yes. In the meantime, Commissioner, after having got the report from the DGI dated 27/11/25, called for the records and directed.
Yes.
Otherwise also.
Mr. Counsel, you just read section 112.
Section 112? Yes. Yes, ma'am.
Please repeat.
Any person aggrieved by an order passed against him under section 107 or section 108 of this act, or the State Goods and Service Tax Act, or the Union Territory Goods and Service Tax Act, may appeal to the appellate authority against such order.
ट्रिब्यूनल।
Yes.
तो इसमें क्लियरली क्या लिखा हुआ है? ये लिखा हुआ है अगर 107 और 108 के ऑर्डर से एग्रीव्ड है तो वो ट्रिब्यूनल में आ सकता है। तो your order is not aggrieved by 107 or 108.
Ma'am, my order is passed by the proper officer on the direction of the Commissioner, and Commissioner has only the authority to give a direction under section 54 section 5, and under section 107 subsection 1 the appeal can be filed against the order of the adjudicating authority, and adjudicating authority does not consist of a commissioner. Read section 2 subsection of adjudicating of the GST Act.
Even otherwise, if your order was passed by the proper officer under the valid jurisdiction, there is no appellate authority available under the DGST Act, because there is no circular issued, no notification issued by them.
Yes.
Our own case in Connecticut, Global Private Limited case, it is pending before the Honorable High Court, wherein they have issued notice to the department and they have had sought information whether any notification has been issued or not. So there is no authority against whom appeal can be filed above the
Appeal against the order of the commissioner can filed again before the speaker authority. No, the similar matter was discussed in the Radhakrishna industry by the Supreme Court.
yes.
So,
Yes.
can I read?
Mr. Counsel, do you have to say anything?
Yes, sir.
Any objection?
The Honorable Tribunal has no jurisdiction to this.
Why? And how do you say it?
When you take Radhakrishna industry case, there the case was under section 83.
Mike, please.
In 83,
Mike.
now when we say Radhakrishna industry, section 83, there was an attachment of bank. One second. Delhi High Court ruling is there on this issue. Written attachment order. There was no appellate authority against the commissioner's orders, because commissioner was not held as adjudicating authority, and there was no tribunal. The High Court, after taking the handwritten note sheet of joint commissioner, like in this case, there the order was passed by commissioner, conveyed by joint commissioner, right? And the High Court should have entered in the petition, right? Now that was a case under section 83, right? When we read section 107, 107 is relevant before we read section 112. One says, why we are arguing this is that before you file appeal, like I told you, you have to find out, can tribunal hear this appeal, and make sure they can hear. If it's a debatable issue, you can have a lot of trouble. Any person aggrieved by any decision or order passed under this act or this states so and so and so by an adjudicating authority. Adjudicating authority is defined in section 2, and Supreme Court Radhakrishna case said commissioner is not deemed to be adjudicating authority because as per 5(2) he had delegated the powers up to special commissioners, right? Now 107 orders can go to appeal in tribunal, no doubt. Now let's go through section 112 before I argue the issue raised by this honorable tribunal. Any person aggrieved by an order passed against him. So what are the two provisions? Under section 107 and 108. What is 108? Let's go back to 108. It's a revisional. So only 107 appellate authority or a revisional authority orders can be appealed before tribunal. The Lacanoi law cannot be made up by the tribunal on any such, even High Court cannot make.
But Mr. Counsel, can a party be left without any remedy?
No. What I'm saying is no. There is a first appellate authority. We might say that he is below commissioner.
Yes.
No, but then he is a first appellate authority. He is to apply independent mind. And all appeals are being filed here.
Do you think that any subordinate authority will go?
That doesn't matter. That doesn't matter. That's a question of national justice. The appeal is a statutory remedy. The tribunal is governed by statute. The tribunal has to be governed by statute. So what does it say further? may appeal to appellate tribunal against such order within 3 months from so and so. Then comes subsection 3. There's a further power to commissioner given here. Then this power is bad. That way we can say the whole section 112 is misconceived. I will agree. But that's what statute writes. There must be some logic. So there is no question of going into legislative intent or natural justice violation something. The statutory remedy is 107, 108. Full stop. The Honorable Tribunal cannot add words or cannot add its own legislative intent to the provisions. If a bill is held unmaintainable, he can go to High Court, like my Honorable Member said, that High Court issue a notice. They constitute an authority. How can you do this with the people? Even I will agree with it. How can commissioner order be heard by a joint commissioner? And how will he take a different view? But then reverse is also true. How can we say he will not take a different view?
But otherwise also once notifications of delegations are issued, so there it's mentioned there that against who can the particular designated authority only can take the
No, but the notification is only first order authority.
But
That's all.
there is no another notification on giving powers to any other authority.
Yes,
who
like
can
in Central, Your Honor, we have a commissioner appeal.
under central. It's not
Again,
under local.
let me make my appeal. There's a commissioner appeal. Commissioner appeal is not above commissioner.
No,
Then how can he hear his appeal? That will be, even that notification is bad in law.
no, not bad enough, but then if you have to go.
Let him go wherever he has to go. What I am saying is, how can this tribunal go out of 112(1)? The sections are mentioned. Adjudicating authority or revisional authority. Radhakrishnan is applicable to the extent, yes, this order is deemed to have been passed by commissioner. It is not an administrative order. 5411 is not an administrative order, it's an order exercising powers. Pending appeal or pending any proceeding, you can withhold the refund. A refund has been withheld, not rejected. It has only withheld. But question is, how can it, if that be so, then in Delhi, so all orders are passed by the commissioner only, special commissioner only. Then where will they go? Therefore, most of the courts said if jurisdiction is to be challenged of the lower authorities, you have to go to High Court and challenge the provision. How can I go a commissioner bill to a deputy commissioner?
Sir, please read, you are referring to subsection 3 of section 112, read subsection 4 also.
Yes, Mona. No, see, subsection 4 to refer only subsection 3.
Yes.
Right? So, it will have the same meaning. Where in pursuance of an order under subsection 3, an authorized officer make an application, commissioner has to authorize to file the appeal. It's okay, there's nothing wrong. It's there in excise also, custom also, service tax also. वो इसमें कोई these things are not relevant because jurisdiction of tribunals will come from 112(1). All other deemed to be machinery provision, what are the powers of commissioner or not powers of commissioner. This appeal cannot be heard by tribunal. It's beyond jurisdiction. He may be allowed to pursue his remedy elsewhere. registrar को privilege है तो
Mr. Counsel, the decision of the bench is that other remedies are also open to you. This is not.
But ma'am, this is the appealable order, and where should I go? I asked the question to the honorable members. Where the appeal should lie?
First appeal authority only.
So first appellate authority is subordinate to the commissioner. Subordinate to the commissioner. Where I will go.
No, Mr. Counsel, once a first order authority is appointed, he detached from commissioner. He is supposed to apply his independent mind. Lakhs of appeals have been filed in Delhi on this issue. The question is, if you want to challenge this provision, then it's ultra virus. I may also agree with you, but go to High Court. This tribunal has no jurisdiction being a statutory authority.
Taking ma'am, the facts in the Radhakrishnan industry case were similar to my case.
Radhakrishnan industry, they were referring adjudicating authority section 107, not 1112. 1112 was not there at all in Radhakrishnan industries. Judgment we have to read very finely. I concede to the point this order is passed by commissioner. The whole factual matrix exists. Because 5411 proper officer doesn't have the power. But if there is a lacuna in the legislation, tribunal cannot add words or delete words. Therefore, other remedies.
Better course is to go to High Court, because if you will again relegate yourself to 107, you can't get any relief. Better to challenge this provision.
And get a direction from the court that some authority should also be appointed.
Already, I showed an Inconnect Global, it's all pending there.
You can also get the directions from the Honorable High Court.
Read number के.
Yes.
Can be filed. But his question is order Refund तो commissioner ने stop किया है. Deputy commissioner को overrule करेगा, दिल्ली से सीधे में कोई नहीं करेगा.
Milord, in that case, direction should be given to file the appeal. No,
How can we say that go to High Court?
if I will go to the High Court, the time will elapse. Time to file.
It's
Delay.
your option. You may decide not to file, and because it is just only refund has only been withheld till the inquiry is conducted. So how can we direct that you go to the High Court only?
The commissioner has the other remedies. He can issue the notice under section 73. Why he withhold the refund? He can issue notice under section 73.
Also, he has the jurisdiction to withhold in such cases also.
And if we read section 54 subsection 11,
Yes.
he has withhold the refund. And 5411 ये कहती है कि if the commissioner can withhold the refund if any proceedings are pending against me. There were no proceeding pending against me.
Pending, you were summoned for verification. That's the meaning of proceeding. The proceeding includes inquiry investigation.
The proceedings
and in Radhakrishnan industries only.
Sir, proceedings were pending against the other.
Against you also. You were also summoned. You were also summoned.
We were summoned in that case. In the third.
Obviously, that's what proceeding is.
Not in my case. Not in my case.
Your case only.
20.
Your case.
Out of 20.
IT से आपने लिया ना 16 पार्टी का.
16 were fake
Dealers are held to be bogus.
Side.
That's your against. So the department is holding inquiry against you on two prongs: purchase side as well as sale side. So their inquiry is there.
The only prayer you should make further is that there should be no further proceeding against me till I exercise my alternative remedy.
वो भी तो सुनाएंगे.
Summon is not a proceeding. Who told you? Who told you?
Armor says so,
Yeah.
yes.
Yeah.
This is that inquiry.
Hello. Armor security was not discussing proceeding. They were discussing initiation of proceedings. So there's a lot of difference. Radhakrishnan industry defined proceeding.
Summons was
Radhakrishnan industry defined proceeding.
Summons were issued to the suppliers, not me.
You are totally wrong. Armor security is not applicable at all. There are not two jurisdictions
I
here.
was asked
The single
to
jurisdiction
verify.
you are talking. Armor security क्या relevance
That
है?
didn't interfere.
But
Since there is statutory.
We are only on 112.1. We can discuss endlessly. 112.1. This tribunal cannot have jurisdiction.
We have heard you, yes.
kindly appreciate the law. What the section itself says. Section 112, what is saying?
Section 112 states that the appeal can be filed against the order of the
107.
against 107. Yes,
Yeah.
but 107 says that we can file the appeal against the order of the adjudicating authority, and the adjudicating authority does not consist commissioner. Where the appeal will file? I will file the appeal to the tribunal. No, I can't go directly to the High Court.
You can file a writ in High Court. Why not?
Oh, your grievance is justified, but
And you are getting order to go to High Court straight away. The tribunal has refused straight away.
This can be.
In the other decision, in the other decision,
Where should I go?
In the other-
If I want to challenge that order.
sir, in the other case industry, the appellant went to the High Court because there was no tribunal at that time. And in my case, the tribunal is here. He should hear the matter. At that time, there was no tribunal. That's why he filed the writ.
No, that was the only issue raised. Rather, that was the only issue was there, not because Tribunal and High Court. They said, listen, in the absence of an appellate authority, High Court should have entertained the writ. They did not go into the question whether you could 112 invocable or not.
But
Rather, they didn't say that at all.
no, they mentioned that.
They mentioned the government took, the petitioner took there is not tribunal.
Yes,
Right?
the petitioner took that point.
Right? So this issue was not there whether this order can go to tribunal or not. They said High Court should have entertained the writ petition. That was only an obligate dicta made by Supreme Court in one of the observations. Otherwise, the tribunal is governed by 112. That's all.
Mr. Counsel, if you have to say something more, what we can do is that we can adjourn the hearing to day after tomorrow and come further prepared on this.
Okay, you just give me more time. I will pursue it on Monday.
Wonderful.
Thank you, Lord.
ये मेंटर साहब ने